The Supreme petition goes on until the Supreme Court sits and the matter before them is decided, and we see how it goes. It can only go two ways, right? All right, Duncan Okach and Judge Keith, the advocates, are still with me on the election center tonight, talking about two petitions, Okiya, Omtata, and Khalifa. And their petitions are not so long, but both of them are taking different tangents in this petition. One, Okiya Omtata is going mathematics all the way and calculating these figures to come up with the exact figure of those who voted, those who never voted, the right figure, if I may say so, while Khalifa is basically dealing with issues of law and facts in this petition. So let me bring Okach. I stopped you, but you're talking about the calculation, and this is where they say actually it's a smoking gun.
Yes, Ken, I was just picking from your question to my learned colleague, Keith, where you were asking whether, you know, when you read this petition of Okiya Omtata, you see logic, it's something that you require logic. My take is you don't require logic. You just require a calculator and you require what was pronounced. Because Okiya Omtata has done a very good petition. This is a petition that I'm sure will be used to teach law in terms of election petitions for quite a long time. Ideally, this is a point where Okiya Omtata has taken the numbers as pronounced by the IBC itself. When elections came to a close, they gave us the tallies as far as the KIMS kits are concerned. And he has juxtaposed those tallies to now the eventual percentage. And you still see there is an anomaly. He has gone ahead and said, okay, let's even leave that. Let me look at what was now pronounced by Chebukati himself. There's still a variance. And you already know that Chebukati gave a tally, and thereafter, 20 minutes thereafter, changed, which is not expected, because once you have a tally, it should remain. And I think that's one thing that
he argues that it can only go up, it can never come down. Once you say 200 people have voted, yes, they have voted. It can only go higher, it can never come low. That's an argument.
And now what he's saying is that what Chebukati pronounced actually gave us a lower number. Remember, like Keith rightly says, the number ought to go up because there are those people who are allowed to vote outside the KIMS kit. So ideally, he has looked even, and this is where I'm having a very big problem, at the percentages as gazetted, because now gazettement is legal. Yeah. It's a legal instrument, which has given us 64.77%. And he has used that to actually give us the tally in terms of what each of these presidential candidates ought to have garnered based on what was gazetted. And you still find there's a deficit in terms of the 50+1. So that's why I'm saying this is the most, lethal petition, because it is as simple as what our young children are being taught, 1+1. It does not require all this, which requires you to go to law school to learn and look at all these laws. But this one just wants you to, any Kenyan can actually take a calculator, as this thing is being argued in the Supreme Court, and should be able to arrive, because these are basic elementary mathematics. So to a large extent, and I think that was a score, like Keith is saying, by taking this, they actually automatically would be able to convince a judge based on the quantitative. I've not seen the response, and I want to see the response. And I've told people
it's tomorrow.
Yes, by tomorrow. Yeah. But at this point, we are actually espousing our views based on what is there. I believe once we see the other one, it will only be fair to then also bring us again to look at that. Then we will have a semblance of what IBC is saying. But at this point, based on this, it clearly adds up. I've not had anyone challenging the mathematics in the Okiya Omtata petition. So this is a straightforward one. All these other petitions are storybooks and novels, which you'll have to read, and that's why people are saying some of them look like fiction movies. So it will take time. Remember this, the Supreme Court has very limited time to hear this. And the Supreme Court may not consolidate, like you have said. These are independent petitions. They will be had together.
Issues for determination.
The issues for determination will be brought out, but each petition will be argued. They'll be had together, just like the BBI petition. We can even have one judgment, but on all the issues. And ideally, in those judgments, each petition will actually have at least paragraphs dealing with that. And I think it is a good way to proceed, because regardless of the fact that we have a lot of petitions, the issues raised will only help us as Kenyans in terms of better management of our election processes.
Okay. Do you want to talk about the figures, or we can go to issues now of law that have been raised by Khalifa?
No, there's a very interesting component that comes out. I've looked at a bit of what other jurisdictions could have handled this issue. One of the issues that comes out is what is the meaning of total voter turnout? We don't have it in law. So it's not a term of art that we can predispose to court and tell them what voter turnout would mean. But then a voter turnout, how it's been handled elsewhere in other jurisdictions, would mean the participation rate or those who cast the ballot of a given election. All right? So participation rate or those who cast the ballot of a given election. Now, that's a germane issue for determination. Of course, we can't get past that again. It's an issue before court. But then it could also mean, interestingly, that percentage of registered voters or eligible voter or all voting age people. Now, for us, because how the law has defined a person called an eligible voter or eligibility to vote, that is, I believe, Section 10 of the Elections Act. That's a person whose name has been entered in the register and must have been captured in name and biometric data. That's the person now who becomes eligible to vote. So then contextually, therefore, in our situation, the person who should vote is the person who's been captured in terms of biometric data as well as his name. Does the manual voter register therefore capture the biometric data question? And the other issue is whether then Kim's kit, single on its own, represents voter turnout, or plus what then the other people voted using the manual register, and the place of manual register in law, the place of the Kim's kit in law, the place of technology versus the universal suffrage right, the right to vote in its entirety. Notwithstanding the tool of trade that you use as IEBC or as a country, I have a right to vote anyway. Whether you deploy manually, you deploy electronically, my right to vote becomes universal. An issue that becomes a challenge as we predispose that as against the figures that are here. Because one of the issues in terms of percentages is the Kim's kit, and also the manual register and a combination of the same. Those are scenarios that Okiya Omtata is playing with here. And I think he has deployed a lot of statistical data and analysis from professionals, because I see he has gone out to give several scenarios as will bring different results. Ultimately, all of them predisposing them to results that do not meet the 50+1 threshold, which then is a good argument of attack. And we're yet to see judges now, for the first time, being lawyers like us, cracking their heads in terms of percentages. And he has also said, you know this argument of rounding off. When you round off a figure, it's normal. You go to the shop and you buy something, if it's rounded off and you're given a shilling, it doesn't sound like an issue. But where one vote counts, for instance, if I get 50% of votes, I can't be the president. But if you add me one vote, and therefore I can be president. Yeah. So it means rounding off, and probably there are 7 votes in that rounding off that get lost or get added. It can be a small issue. Rounding off, therefore, must be prohibited in an election for the reason that we have one vote that counts. The threshold is 50%. So if it's 4 million, plus one vote.
So if you round it,
off, and there's 6 votes are either added or lost on account of rounding off. Therefore, that becomes a big issue because of that one vote, you have 5 more votes that are unaccounted for, which means therefore rounding off cannot be applied in an election with the threshold that you have set, which is a very strict thin threshold.
Indeed. Do you want to go to the figures, or we can go to issues of law now? Violations?
We can go to issues of law because issues are more.
Yes. Let's talk about the violation, because strictly, Khalifa is basing this on how this election was conducted. I mean, it should be a simple election, but there are parameters that must be followed. So take us through. If you look at that petition, does it have a point in terms of, because eventually he asks the court to impeach this on the basis of violation of law and the Elections Act, and how this election should have been conducted?
Yes, Ken, I think the Khalifa petition has really, as we've indicated, broadly majored on the qualitative issues of an election and the requirement by law, especially Article 81, 86, and 138 of the Constitution. The major issue, and these I think many of the issues for determination will actually be crafted, especially in terms of the qualitative from this Khalifa. Because the other petitions will be like they are just bringing additional evidence. But this one has isolated issues even by itself. And you'll find that the major issue is what Kenyans have been asking themselves majorly in terms of the role of the chair, in terms of the pronouncement, and the role of IBC in terms of what is required by Article 138(3)(c) in terms of tallying verification of these results and owning those results. Ideally, they have gone extremely deep in terms of giving us the history. And this started from the Kriegler tribunal or committee. To that particular extent, it went to the Maina Kiai decision, which actually gave us, for the first time, a way forward in terms of the role of the chair. And as much as there's that argument that the Maina Kiai case was mainly dealing with the preventing the chair from changing the Forms 34As, but ideally it went further and even gave the role of the chair vis-a-vis the role of the other commissioners. And it really gives life to Article 138(3)(c). And when we are reading the law, the point of departure, and even any first-year law student will tell you, is that the Constitution will always reign supreme. You do not start by looking at regulations or the acts of parliament. Just read the Constitution, which is written in plain English. It should be able to tell you, and that's how constitutions are drafted. Our Constitution under Article 138(3)(c) is very clear in terms of the stages, and it is very, very important, as buttressed by Maina Kiai, in that people will vote at the polling stations. The results from the polling stations will be, after they are counted, those results are captured in Form 34A. Those results are then quantified and captured in Form 34B by the constituency returning officers. Those are the results that are now taken to Bomas, where IBC as a commission is sitting. They ought to look at those results. They ought to verify as required by law, mandatorily required under Article 81. And this role is given to IBC, not the chairman, not the vice chairman, not a commissioner. It is IBC itself. Commission. To a large extent, at this particular stage, they ought to verify. And if even one commissioner abrogates this duty, then that commissioner is not worth their salt. And they are actually demeaning the aspects of Article 138(3)(c). So to that extent, they ought to all verify. Once they are verified and looked at the originals once they've been brought, of course, even if they see there's an issue on Form 34A, they cannot change. That is the role of the court. But after they are verified and they've noted any issues that they have, they ought to, within themselves, agree on.
34C, I think, can be changed.
34C can be changed. I'm saying 34A cannot be changed. Yes. And if there are issues, you'll note them down. 34B can be changed because it's arithmetic.
I know. I want to go to Khelef, but let me ask you this. Yeah. There's this argument that then you will be putting this role so high as opposed to giving meaning to the votes that came from the people. If commissioners can sit, the 7 of them, and 4 of them are divided on which results. So, for example, Okiya, Mwaure, Raila, and Ruto were there. So, when you say that they have to agree on the final tally, they argue that it's like saying that, oh, no, let's not give this 50% plus 1 to Ruto. Let's give it to Raila or to Okiya. That's how trivial they're looking at it. No. That is, it's far from it. Actually, all they need to agree in terms of the verification. And that is what happens even at the polling station level. If one says it's 8 million, the other one says it's 7, the other one says it's 5, they're divided in this. Then the IBC Act itself is clear in terms of how those decisions are made. And they will make it by unanimity or majority of the commissioners. And to that extent, if I may finish, with that decision, if there's any challenge, that is what now goes to the Supreme Court, if you have an issue. But as a commission, what ought to be pronounced by the chair is actually what has come from the plenary of the commission. George, I'm told we have about 5 minutes because of the news, but tell me this, what is the place of Article 138(10)(a)? Because 138(10) gives that power exclusively to the electoral, to the chairperson, who they say shall announce. So is that an argument that can fly? Because it's in the Constitution, shall announce. Because at the end of the day, they say, but we fulfilled our constitutional obligation by the chairman who had until midnight to announce by making that announcement on that day.
You know, I'll reply to this dual form that, one, we legislate a lot because of how we've really suffered as a democracy in this country. Honestly, as a country, we've paid a lot of price to get where we are in terms of democratizing or forcing democracy upon our leadership in this country. And you'll agree with me that we've shed blood on this. We thank God we are where we are now, this time round, without having problems, but we hope it continues like this. Now, we legislate using, therefore, what we call the mischief rule, where we are trying to curb something not happening. When you do that, then you box the person with power on against exceeding the powers. So it becomes against the ultra-vires rule, where the person cannot extend that power. When we do that, we legislate continuously within that box. We start with the Constitution, where we put a box, you can do and you cannot do. And therefore we put parameters to the extensity at which you can apply your powers. Against that, then we cascade the powers down to legislation and eventually to what we call rules. So when you start to be safe, therefore, as an officer of serving in any government position, as in IBC, you first have to work within the parameters of the Constitution. Because that's supreme.
Yes.
Then you are guided eventually by how we cascade those powers and expound them more within the law. Therefore, you go to statutory legislation, which is acts of parliament like the Elections Act. Against that, therefore, the finer detail comes in the rules. If the rules conflict with the statute, you follow the statute. If the statute conflicts the Constitution, you are safer standing with the Constitution. So eventually, a rule cannot override a constitutional provision. The constitutional provision rules run supreme. Start with the Constitution and cascade downwards and see how the rules apply. I have seen that the regulation here, at a point in terms of interpretation, may at a point give more powers to a person as opposed to what the Constitution does.
That was what Minor dealt with.
Yes, but again, there's a question of interpretation. When you interpret, you read within the Constitution. You read the regulation within the force of the Constitution, which means if you have to work as, for instance, a pool of commissioners, it means, therefore, consultation, approval, verification with those commissioners is important. However, one person shall be mandated to pronounce it as has been consolidated and verified as a decision of the commission. Remember, a commission has a definition on what it is. It's a composition that has been put into law. Therefore, ultimately, the pronouncement has to be that of the commission and not by an individual, which is a main issue for purposes of discussion before the Supreme Court, eventually.
Okay, because we are out of time, I'd like you to summarize your take on the two petitions. In just summary, 1 minute, then I'll give him 1 minute. Your take on them.
The Khalifa petition, we still have the KPMG issues, system issues, the issues of technology. So it's a myriad of issues, but ideally, all of them, in my view, are important. And I think at this particular stage, we'll wait for the responses, because they'll shed light, because the people who are being accused have a right to also respond. And I think at that point we'll have a whole picture, because today we only have half
one
the
side,
picture.
yes. Yeah, one side. Okay.
I think we are growing as a nation. We are growing the fine needs of jurisprudence. Ultimately, I think what we're going to bring out is a finer utility of the Constitution and how it can guide us. I have seen what Okiya Omtata has done. I've seen what Khelef has done. These are seasoned litigants. What I think is the fusion of the qualitative approach and the quantitative approach, in fact, bring a higher model of a jurisprudence that has never been experienced anywhere, probably in Africa or probably the world. These are first among many. What I think we'll do is, let's give it, as lawyers, we ought to give it our best so that then we can grow this. What we did last time is we pushed the Supreme Court to give a finer detail on what should be tabulated and ought to be done until the final result is pronounced as for the presidential election. What we are doing now is then looking at a breakdown or how we come to the figures in the first instance, and then how we prepare for that election petition in Khelef, Khalifa, eventually how we manage the election and how we give more power, donate more power to the voter as opposed to the officers, the commissioners.
Gentlemen, we have to end because the news is coming up, but this is an invite for Monday. Monday is Kivumbi. And because we have not concluded this, based on the fact that we don't have the other side, we don't have the responses, I'd like to talk to the two of you when finally we have the responses. And the responses are in by tomorrow latest, right?
Yes.
So let's look through them over the weekend. And on Monday on Kivumbi, I'd like to have both of you.
It's
on
a day.
Kivumbi.
It's a
And
day.
we have about 1 hour, 30 minutes for that.
Thank you.
George
Dear
Kithi,
pleasure.
Duncan Okaj, thank you so
Thank
much
you.
for coming tonight. Jesse Rogers is up next with the Prime News, and of course the discussion on the Supreme Petition continues right here on Kivumbi 2022 until the Supreme Court sits and makes a decision. And as I say, can only go two ways. Have a good night.